You were right. I was wrong. Morning, Your Honor. For the record, Brian Stacy, P 33014. State your name.
Caitlin Quinn.
All right, I have before me a plea form that indicates that she's going to be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's, of course, full understanding of the.
That's accurate, Judge. I have had an opportunity to explain to my client her rights in detail. I believe she understands them, and at this time, knowingly, voluntarily waived them and lay a factual basis to the added count.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty. Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep. Yes, Your Honor. Yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of September 4th, 2025, Washington Hogback Road, Pittsfield Township, Washington County, State of Michigan, did you have methamphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
All right. Ma'am, if I accept your plea, I have to advise you that if you commit misconduct between, as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11th, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly,
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use
No.
cocaine after.
no, there's, well, go ahead, Counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail, since she's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention. And she was hoping her daughter's 15 years old. She's homeschooled, and her grandmother is 86 years old, and she's been diagnosed with Alzheimer's, and she was hoping to move in with her, and her daughter would be with her and to help take care of her grandmother. Her mother, I believe, is.
As the hearing continues, the focus quietly shifts from the charge itself to the defendant's future. The judge isn't just looking at what happened in the past. He's trying to decide whether she can be trusted moving forward. Her answer to a simple question about staying clean could influence whether she gets another chance outside custody.
You going to be able to test clean if I let you out?
Yes, sir. I've learned my lesson, Your Honor.
I'll reinstate her previous bond with the testing. And so she'll be released on PR.
Thank you very much for your consideration today, Judge. You have a good day.
You do the same.
Thank you.
Court does call the case, People versus Jennifer Burnside.
Javante, would you state your name on the podium? Sir, my name is Javante Cadell. Judge, we're asking to set this matter for exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available February 10th.
Judge, may I address bond?
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge. Fresh hour. Esteban.
Judge, this young man's 18. He has no criminal record, juvenile record. It's my understanding, he was living at Ozone, who was trying to place him with his own apartment. I understand there's a $10,000 bond because he missed a court date. He did not have a ride at that time. What I'm asking the court is, I've spoken to this young man. He promises to appear for all future court hearings. We would like to get back to the Ozone so he doesn't lose his place as far as getting a placement, and he can be gainfully employed. We would just ask the court to set a PR bond in this matter.
Any response from the people?
Your Honor, I'll leave it to the court's discretion. If it helps the court decision making at all, the co-defendant's case that was set for a claim on Tuesday and got dismissed because we were unable to proceed at that time.
Got it. How do you come back into custody?
Were you arrested or did you?
I was arrested, sir. My casework was supposed to call due to the weather conditions. He said he called, but I guess, but I was picked up, sir.
What were you doing when you were picked up?
Trying to get to one of my friends' house. But sir, I tried to make it to court. The weather conditions was hard. I ain't have a phone. It was cold. My phone died, sir. And I tried to my caseworker, he tried to help me too, make sure I made it to court, but he couldn't help me.
You grew up in Michigan?
You said what, sir?
Did you grow up in Michigan?
Yes, sir.
You're going to appear for all future.
If it was too cold, then we're getting soft.
Nah, it wasn't even just that. I didn't.
In cases like this, the courtroom becomes more than just a place for legal decisions. It becomes a test of responsibility. The judge has already given a second chance, but with that comes a clear expectation: show up, follow the rules, and prove that this opportunity won't be wasted.
Have the right clothing either, sir. And I was willing to walk
I got you.
through the distance.
I got you. I'll reinstate his previous bond. I'll grant the reduction. Reinstate his previous bond, but you better show up on the 10th. You hear me?
Yes, sir.
You got to start out walking on the 9th. You better show up on the 10th.
Yes, sir.
You call me, okay?
No, sir.
Let me just see real quick.
So his previous bond was reinstated.
He right away here, boss.
Thank you, Judge. Appreciate your consideration for this young man.
Court does call the case People versus Gary Coward.
With the people.
Morning, Your Honor. Jason Hagelthorne on behalf of defendant Jennifer Bernstein, who's present standing.
Morning,
by.
Your Honor.
Good morning. Your name?
Jennifer Burnside.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year. On her successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to enroll and participate in the 14A sobriety court. There is also a sentence agreement. Well, it just says the 14A, it says A3, but it's 14A sobriety court. Defendant has been accepted as of January 29th, 2026. That's, and there is a sentencing judge waiver checked off. That is the court's full understanding of the agreement.
Yes, Your Honor.
Yes.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Jennifer Burnside.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle forfeited or could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
I do, Your Honor.
You wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your
You
Honor.
understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily
I am, Your Honor.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 10th, 2025, at the location of I-94 near Freer Road in Sylvan Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed, I guess, alcohol and cocaine
I did, Your Honor.
and THC also.
Yes,
Is that correct?
Yes.
All right. Were you stopped by the police?
Yes, I was.
All right. Why'd they stop you?
My turn signal was burned out
All right.
when I went to go get on the highway.
All right. Were you arrested?
I was, Your Honor.
Were you taken to the hospital for a blood draw?
I was, Your Honor.
And what were the results of that blood draw regarding alcohol?
0.97, 0.097.
0.097. All right. Did it also show the presence of cocaine or its derivatives as well as THC and or its derivatives?
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And ma'am, had you previously been convicted of operating while intoxicated on or about June 25th, 2023 in the 53rd District Court and operating while impaired on or about February 25th, 2006 in Farmington Hills District Court?
Yes, Your Honor.
All right. Ma'am, if I accept your plea, I do have to advise you if you commit misconduct between the time I accept your plea and the time of sentencing in this matter, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
All right. And have I complied with the court?
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 3, excuse me. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation. Sentencing in this matter will be March 9th, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor, I did have one request renewed from the last time we were here. Ms. Burnside has a pretty severe cut. I know the probation, the testing facility, Keith over there had checked that he has recommended her, and I believe he's going to accompany her to medical for that. They did switch the leg, but based on that, would the court be willing to transfer to the sober link and a release of that tether?
Response from the people.
Judge, we'd ask, being a photo manager in the next going to the sobriety court, we'd ask that the tether remain. If the court is willing, Mr. Heaton did give us a possible sentencing date of February 12th, and then Judge Fred.
That date can be moved up. I'm not moving it up because I don't have a date.
Fair enough.
So you guys can do that, and if you can get it moved up, then that's fine, and I'm not gonna remove the tether. Her bond will continue as is. Thank you.
Thank you, Your Honor.